Hey all, greetings to everyone. Welcome back to Samsware, your weekly compliance tracker. We are Samsware Advisory Private Limited, a one-stop shop solution for all of your compliance needs. As promised, we are back with the weekly updates related to global compliance. Before we proceed, let me remind you all to click on the bell icon below to never miss out on any regulatory update that might affect you as a business entity. Let's proceed with our headlines this week. The Code of Wages Bill 2019 has been passed by the Upper House in India and is awaiting the President's assent. The Code of Wages Bill 2019, seeking to regulate the payment of wages and bonuses in all establishments where industry, trade, business, manufacture or occupation is carried on, has now been passed by the Upper House Rajya Sabha and is awaiting the assent from the President to become a law. The code proposes the repeal of the Payment of Wages Act 1936, the Minimum Wages Act 1948, the Payment of Bonus Act 1965 and the Equal Remuneration Act 1976. Highlights of the code are prohibition of discrimination by employers in payment of remuneration on the basis of gender in respect of the same work or work of a similar nature, fixation of a minimum wage by the appropriate government, prohibition to pay wages to the employee at any rate lesser than the prescribed minimum wage. The minimum wages shall be for time work, piece work and for the period by hours or day or month. Revision of minimum wage by the appropriate government every 5 years. Overtime wages to be twice the amount of regular wage. Wage periods may be daily, weekly, fortnightly or monthly and no wage period shall exceed a month. A mandatory bonus at the rate of at least 8.33% of the wages drawn by the employee shall be paid by the employer to the employee if such employee is drawing a minimum notified amount of wages and has worked for a period of 30 days in an accounting year. New trademark law will come into effect from November 1st, 2019 in China. The 13th Standing Committee of the National People's Congress recently passed the 4th Amendment to the Trademark Law of China, and accordingly, the said amendments will come into effect starting November 1st, 2019. The most significant new revisions to the trademark law are bad faith being ground for rejection, opposition and cancellation. An application or registration for a mark that is not intended for use will be considered as a bad faith application. The bad faith applications are now considered as a valid ground for rejection, opposition and cancellation of trademark applications and registrations. Trademark agents prohibited from handling bad faith filings and punished for violation. A trademark agent assisting in any bad faith application while knowing that the applied mark is not intended for use will now be subject to warnings, fines, administrative punishments and court sanctions based on the circumstances of the acts. Counterfeit commodities and materials or tools for manufacture to be destroyed. The court may order for destruction of any commodities bearing counterfeit trademarks and the destruction of the materials and tools mainly used for manufacturing counterfeit commodities without granting any indemnity if the owner of the trademark requests so. Enhancing punitive damages and statutory damages. The cap amount for punitive damages for willful trademark infringement to be increased from 3 times to 5 times the amount of the actual losses suffered by the rightful owner, the proceeds earned by the infringer or reasonable multiples of trademark license fee. The upper limit of statutory damages will be raised from Chinese yuan 3 million to Chinese yuan 5 million. The United Kingdom publishes draft legislation on the European Union Directive on the mandatory disclosure and exchange of cross-border tax arrangements. The draft legislation proposed by the United Kingdom on the European Directive on the mandatory disclosure and exchange of cross-border tax arrangements is called as the International Tax Enforcement Disclosable Arrangements Regulations 2019 and is currently subject to public consultation. If implemented as currently proposed in the draft legislation, the International Tax Enforcement Disclosable Arrangements Regulations 2019 will be broadly aligned to the requirements of the European Union Directive on the mandatory disclosure and exchange of cross-border tax arrangements. It will adopt many of the definitions from the directive, including of the terms cross-border arrangement, hallmark, intermediary and relevant taxpayer. The European Union Directive requires intermediaries and in certain circumstances the taxpayers to report certain cross-border arrangements to the relevant EU member state tax authority. This disclosure regime applies to all taxes except value-added tax, customs duties, excise duties and compulsory social security contributions. The draft legislation is expected to be finalized by December 31st, 2019 to comply with the directive and to come into force on July 1st, 2020. Hong Kong Tax Inland Revenue Department clarifies methodology for attributing profits to Hong Kong permanent establishments. The Hong Kong Inland Revenue Department issued Departmental Interpretation and Practice Note 60 to clarify how it will interpret the concept of permanent establishment in Hong Kong and the methodology for attributing profits to Hong Kong permanent establishments. The permanent establishment status of a business entity will be determined based on whether the business entity belongs to a jurisdiction with which Hong Kong has an income tax treaty. If Hong Kong has an income tax treaty with such jurisdiction, then the permanent establishment status of such business entity will depend upon the terms of such treaty. If Hong Kong does not have an income tax treaty with such jurisdiction, then the permanent establishment status of such business entity will be determined under a newly enacted section of the Hong Kong Inland Revenue Ordinance. The definition of permanent establishment in the Hong Kong Inland Revenue Ordinance generally follows the permanent establishment definition in Article 5 of the OECD Model Tax Convention. Article 5 of the OECD Model Tax Convention can be found in the links in the description below. Attribution of profits and expenses to the permanent establishment. Permanent establishment is allowed to reduce its income by direct expense allocation from its headquarters, such as cost of general management, administration and support services, research and development costs. Certain expenses such as guarantee fees, royalties and interest charged by its headquarters are not deductible by the permanent establishment in computing its taxable profits. Profits attributable to an agency permanent establishment should reflect its functions performed, risks assumed and assets used. The profits of a permanent establishment should be determined before considering whether the income or profits attributed to the permanent establishment are subject to Hong Kong profits tax. A permanent establishment's interest expense deduction is limited to the permanent establishment's debt to equity ratio that is solely based on its headquarters debt to equity ratio. This will also give rise to a permanent establishment level thin capitalization concept. Malaysia Amends Companies Act 2016. The Companies Amendment Bill 2019, which was recently passed on in the lower house of the Malaysian Parliament, will soon be put forward for approval at the upper house. The key amendments proposed are introduction of execution formalities for specific documents. The newly introduced Section 66, Subsection 6 of the Companies Act 2016, introduced Wide Companies Amendment Bill 2019, provides that certain documents that are required to be executed by any written law, resolution, agreement or constitution shall be executed by way of the affixing of a common seal or signature of at least 2 authorized officers, one of whom must be a director. Redemption of preference shares. While redeeming the preference shares from the capital, it has now been clarified that transfer of a sum equal to the amount of shares redeemed into the share capital account of the company will only apply where the redemption of preference shares is made out of profits. Appointment and remuneration of auditors at annual general meetings. The bill has clarified that the appointment of auditors and their remuneration must be one of the businesses to be tabled at the annual general meeting of a public company for shareholder approval. Plaintiff companies to provide sufficient security for costs. To prevent frivolous claims and abuse of process by parties seeking to initiate legal proceedings, the bill will empower the High Court to require a company initiating legal proceedings as a plaintiff company to provide sufficient security for all costs and to stay proceedings until such security is given. That's it for today. I request you all to like and share our content. Feel free to comment below with any queries that you may have related to compliance. We will do our best to solve them. You may also contact us through our Twitter handle, Facebook page, LinkedIn page or our website. Links in the description below. Until next Monday then. Thank you.